Thank you for joining us for another episode of Baker Host's Ad Nauseam, a podcast series focusing on new and trending advertising issues with an emphasis on the FTC and the NAD. I'm Randall Rubenking, and you're listening to Baker Hosts. We are once again joined by Amy Mudge and Daniel Kaufman, two partners from Baker Hostetler's advertising, marketing, and digital media team. Together, they have decades of advertising experience and approach advertising issues from multiple perspectives. On today's episode of Ad Nauseam, Amy and Daniel have a returning special guest, Randy Shaheen, their partner at Baker Hostetler in the advertising, marketing, and digital media practice. Randy also teaches advertising law at Washington and Lee and will put on his professor hat to guide a discussion on the Supreme Court's Loper decision that overturned Chevron, a longstanding doctrine that gave considerable deference to agencies, including the FTC. How this impacts advertisers on a practical level right away and in the future is today's topic. With that, welcome to Ad Nauseam, and let's turn it over to Amy and Daniel.
Welcome back to Ad Nauseam, and thank you so much for joining us. We have a big topic for you today, and that is the Supreme Court's Loper decision, which struck down the Chevron doctrine. And for us, that means we got to bring out the big legal guns for this discussion, our very own Randy Shaheen.
Da, da, da! Professor Shaheen is in the house again.
Thanks, Amy and Daniel. I'm not sure about the big gun description, but I'm always happy to join the two of you, and I'm really glad we scheduled this because it gave me an excuse to sit down and really go through all the different opinions here. Quick bit of trivia with respect to administrative law. I had Justice Breyer for that subject when he was still a circuit court judge, but I have to confess I've pretty much long since forgotten everything he had to say on the topic.
Okay, you two giant nerds. I happen to know for a fact that you both dove into this decision like the second it came out and probably started going back and forth. I think it was a Friday, like all weekend. So you can play it all cool, but I know you have been chomping on Chevron or Loper since it came out. But, look, we've all been reading quite a lot about the decision and what it means. And, needless to say, there's a lot of misunderstanding out there about what the immediate impact of this thing is going to be, as well as what it means for the future, particularly with regard to our beloved agency, the Federal Trade Commission.
Yeah, Amy, I was watching a hearing and I saw one member of Congress suggesting that the decision somehow meant that agencies would just automatically start rescinding rules. Well, that's, of course, not the case. But I figure, look, given that we're going to be quite lawyerly, we're going to be a little scholarly today, I thought the question I would ask today, favorite TV or movie focused on lawyers? And let us kick it off with Randy.
Oh.
So I'm going to date myself here again, but I have to go with Paper Chase. I love Professor Kingsfield.
Okay, I don't even know if I know what that is. No, kidding. All right, I loved LA Law, but Ally McBeal, baby, that was my jam. When I started practicing law, I'm sure there are a few pictures of me selecting my wardrobe, so I look just like Ally McBeal. I will say I don't get the recent obsession with Suits. I'm like, on Suits. I think that's a millennial thing and just not loving that one. What about you, Daniel?
Wow, I had not thought of Ally McBeal for years, and that's where Portia de Rossi got her start there. No, I was a huge Ally McBeal fan, but for me, Better Call Saul. I did the whole Breaking Bad thing years ago, and then I turned to Better Call Saul. And I will say it took me a few times to get into it, but once I got into it, I was fully hooked. It was an amazing show. Again, not exactly a positive portrayal of lawyers, to be clear, but really well done.
I thought you were going Night Court. I thought you were going old school 80s Night Court, but, good.
I love me Night Court also, but Better Call Saul, just spectacular.
All right, so now that you've got your Ad Nauseam TV recommendations out of the way, let's get back to this topic. Randy, let's set the stage. Remember, we've only got about 20 minutes, but in a pithy fashion, what is that Chevron doctrine, and why do we or did we care about it?
Sure. So, as Daniel was saying, there's been a lot of conversation out there about this, and I think to some people it just means courts aren't going to defer to agencies anymore, full stop. But the Chevron deference is really a specific kind of deference, and it's deference by a court to how an agency interprets a statute that it's supposed to administer. And when a statute is ambiguous, as sometimes they are, a court would defer to any reasonable interpretation that the agency put out for that statute, such as here the FTC. And as I said, this is particularly significant, or used to be significant, because Congress rarely legislates with sufficient precision, right? You've got people trying to strike compromises, and they use kind of fuzzy language and figure we'll fight about it later. So it was not all that unusual for statutes to be ambiguous.
So Chevron was decided 40 years ago, but certainly for the last few years, have we've seen more decisions where courts have been certainly less inclined to defer to certain agency actions or interpretations. We all have been wondering how long the doctrine would actually survive. And certainly on June 28th, we got a very clear answer.
Yeah, it's interesting. I think folks have thought for quite a while the writing was on the wall, and the majority opinion notes that the Supreme Court, at least, has not used Chevron deference since 2016, so quite a long time ago. But then once we got to this case and cert being granted, I think everyone was predicting something was going to happen to Chevron. But what would it be? Would the court set up some other standard for deference, strike it all together? And we have the answer. But the majority opinion strikes it down completely, saying basically, look, it's the job of judges. Judges are good at interpreting laws, and that's their job. And there's just not going to be any more deference to administrative agencies in that regard.
So where will the FTC continue to be given deference, if anywhere?
So I think that's where it's important to kind of focus on exactly what Chevron deference was, right? And certainly the Supreme Court has been no friend of federal agencies generally and the FTC specifically in recent years. So who else knows where they may cut back on the agency. But I think, for now here, there's no reason why courts won't continue to defer to FTC factual findings, right? Chevron is about deference to legal interpretations, not factual interpretations. So if the agency finds that an advertiser has engaged in a particular course of conduct, that finding will be given deference. That's a factual finding. But whether Section 5 or some other statute that the FTC administers should be interpreted to make that course of conduct unlawful, in other words, okay, here's the facts as we find them, does that make out a violation of law? That's what implicates Chevron deference. And so the courts are not going to defer to that second piece. Do the facts constitute a violation of law in terms of how the law should be interpreted?
So the impact of the decision really is quite broad, although it's not unlimited. Most of the stuff that I've read, the focus seems to be on issues involving environmental regulations, a fair bit about financial regulations. But for today, kind of narrowing in on our slice of the pie, mainly how will this play out or not play out with respect to FTC rulemaking, and then its legal enforcement. The first shoe actually just dropped for the FTC just a few days after Loper Bright was announced. Daniel, why don't you tell us what happened down in Texas?
Yeah, no, it's really interesting. So as we probably all know, the FTC issued this non-compete rule, which has been highly controversial, immediately challenged through several different court actions. And a few days after Loper Bright comes out, Texas District Court invalidates generally the new FTC non-compete rule. And among other things, the court cites to Loper Bright in reaching that decision. But of course, what's also really interesting is a week or two later, we've got another decision from a different federal court, this one in Pennsylvania, reaching a completely opposite conclusion with respect to the non-compete rule. And I can guarantee by the time this podcast is posted, we're going to hear probably again by the Texas court. But again, it is being cited already frequently in court decisions.
Yeah, and I saw just the other day or just yesterday, another case has been filed in yet another venue. So we'll see how the scorecard goes in this regard. But I think the key thing to remember about the non-compete rule, it's kind of an unusual animal, right? It was premised upon a statutory provision of the FTC Act that doesn't usually get much attention, Section 6G, and whether the FTC could even promulgate substantive rules under that provision. Most of the commission's work that we're all familiar with is done under Section 5, which regulates deception and unfairness. And there really hasn't been much controversy over the years about what makes up the legal elements of deception, right? People aren't arguing over exactly what the legal interpretation of deception is, as opposed to whether the facts constitute deception. But with respect to unfairness, over the years, there has been a lot of back and forth about the scope of the FTC's unfairness authority, what constitutes unfairness. It's pretty ambiguous as ambiguity goes. And the FTC, this particular FTC, has been pretty aggressive about looking at unfairness in a very expansive way. So with respect to privacy, for example, and whether non-monetary injury is the type of injury that satisfies or that constitutes unfairness under the law. So I could certainly see some arguments, some invoking of Loper on the unfairness piece of Section 5.
Okay, Randy, I think when you're talking about the non-monetary injury, you're talking about the Kachava case. Daniel's going to have drool coming down. We're going to have to gag him and put him in the corner because that is his absolutely favorite case. I'm not sure if we've had a podcast where Daniel hasn't tried to take us off into a Kachava tangent. So
and I think I read the other day somewhere that there were settlement talks going on in Kachava, and I was very upset because
oh no, we need a decision, right?
All right, Daniel, you got to go back and get some of that pullback you had at the FTC to make sure you're. But anyway, we will, Daniel. I will give you a Kachava future podcast if
Excellent.
we will. But we are staying on track for this one. So, but Randy, you raised an interesting point about the FTC's authority, and the FTC's rulemaking authority actually falls under even a different statute, not Section 5, but Section 18 of the FTC Act. And currently the FTC, they were on a rulemaking binge, all right? They finalized the imposter rule using that authority. There are proposed rules on junk fees, on consumer reviews, on updating the negative option rule. And, farther down in the pipeline, we've got rulemaking on earnings claims, and then this kind of amorphous commercial surveillance rulemaking. But let's be clear, the general statutory language in Section 18, and I'll quote it, is pretty clear. The Commission, quote, may prescribe rules which define with specificity acts or practices which are unfair or deceptive, acts or practices in or affecting commerce. Now, that's a pretty clear grant of giving the FTC some rulemaking authority, but how broad will courts let the FTC go with this language now?
Right. And of course, look, we can't just look at Loper Bright in a vacuum. This is where we also have to keep in mind other recent decisions from the Supreme Court, most notably West Virginia versus EPA, where the court basically said it was going to be looking really closely at the specific grant of authority at issue to see had Congress properly delegated that scope and amount of authority, particularly when we're involving issues of major questions.
Yeah, and no one's challenged the imposter rule yet, and it may end up being one of the few that doesn't get challenged. But when rules do get challenged, I think we can expect that rules that kind of stay in their lane, that narrowly target known deception issues, are likely to survive, or more likely to survive at least. The court's not going to defer anymore to the FTC's interpretation of what Section 18 means from a legal standpoint. But again, if they're staying narrowly focused on something like the imposter rule, I can see that making the cut because it sticks very closely to what Congress presumably intended when they drafted Section 18. But if the FTC starts to use Section 18's language to promulgate some broad, overreaching rule like the proposed privacy rule, that may end up quite differently in court. Or maybe, to Daniel's point about the West Virginia versus EPA, someone will file a challenge in the aggregate to this, huge flurry of rulemaking that's putting, if all of them were finalized, would put essentially every consumer transaction under a rule, and argue that can't be what Congress intended when it gave the FTC rulemaking authority.
And, look, I can also imagine a challenge to the FTC's expansive use of these penalty notice letters, and a question being raised as to whether that also falls within what Congress intended, perhaps.
Oh, Daniel, that's really interesting. I think we've talked about that notice of penalty offense letters being attacked from day one, since the first time they came out. I guess they FTC probably hasn't tried to use them in ways they've threatened, but yeah, this will give another really good avenue to go after that. But let's turn to cases and enforcement, and it's not like the Chevron case was regularly cited in the FTC's litigated cases. The courts evaluating a regular Section 5 case really weren't looking to Chevron to help understand how the FTC was interpreting Section 5. So, it might be an issue when the FTC is stretching the bounds of FTC, but for more run-of-the-mill deception or unfairness cases, Loper probably is not going to be any kind of game changer.
Yeah, I think it might have much more of an impact in other areas where the FTC is enforcing other specific statutes or rules. Certainly, COPPA comes to mind, and certainly for our purposes, ROSCA is probably leading the pack. ROSCA, of course, is a pretty simple statute. It doesn't have a huge amount of specificity, but it has 3 basic requirements that companies must meet when selling products or services online with a recurring billing feature. Statute requires material information be disclosed, that the seller obtain the consumer's affirmative consent, and that there be a simple method of cancellation.
And that last one, the simple method of cancellation, is where it gets interesting, because all the statute literally says is that the seller has to provide a simple mechanism for a consumer to stop recurring charges from being placed on a consumer's credit card, debit card, bank account, or other financial account. That's it. So, but all of the guidance and policy statements that the FTC has been putting out lately about what it means to be a simple mechanism for cancellation is no longer going to get any deference from a court. And that's a pretty big deal here, because I think a lot of us believe that the FTC has perhaps strayed from simply requiring a simple method of cancellation.
Absolutely. Now, we're not suggesting you rip up your copy of the FTC's negative option policy statement. It does sound, though, like Loper at minimum expands the zone of advocacy in some of these areas. And, maybe, and it's a big if, maybe the FTC might think twice about whether to bring some of these closer call cases, or in some of the cases that are pending right now, hopefully the FTC will consider settlement on some more reasoned grounds.
There's some wishful hoping and thinking there, but no, I totally agree with you, Amy.
I'm an eternal optimist, D. You know that.
You know it. I am totally, the glass is empty. But look, here too, the FTC is also attempting to create a rule involving negative options that would put most of those interpretations of ROSCA into a rule. And that is perhaps an insurance policy now for the FTC against the lack of Chevron deference to how it's been interpreting ROSCA. But if a new rule is viewed by courts as stricter than what ROSCA requires, it's a real open question. How are courts going to react to the FTC using its rulemaking authority to craft restrictions that go further than what Congress thought was necessary when they were regulating on that very specific same issue? So, Randy, there is so much that's going to evolve here as we see courts interpreting Loper Bright, and as we see whether the FTC changes course at all in any areas or continues to broadly interpret all its authorities. So what are your takeaways that companies should be thinking about vis-a-vis the FTC and this very significant decision?
Thanks, Daniel. I'd say for now, 3 things. First, don't dramatically change how you consider and evaluate FTC risks and concerns. Continue, as Amy said, to pay close attention to FTC guidance. But if there are areas, and there may be some, where you think FTC guidance has gone a little bit too far, it's at odds with specific statutory authority or language, then yeah, on the margins, you might want to take a closer look at what the real risk might be here. Again, as Amy said, the FTC may be reluctant to push things too far given this development. Second, talk to your marketing people. Make sure they know, right? Who knows what they're listening to or what they've heard on social media or elsewhere. Make sure they understand that things have not dramatically changed. Consumer protection rules and laws survive. The FTC is still very active. Nothing is happening dramatic overnight. And then third, if you are in litigation with the FTC or just in an investigation, this is certainly another kind of arrow in the quiver to think about, right? Are there issues you can raise in terms of how the agency is interpreting its statutory authority that you might be able to assert in a white paper or elsewhere to try to gain a little leverage in negotiating or settlement.
Randy, thank you so much for joining us. I have to say, I make fun of these heady topics, but it's important that we take them on, along with things like puffery. And it's awesome to have a partner like you who can help break these things down in a simple way. It makes hard things easier to understand. So we're always grateful to have you joining me and Daniel Kaufman for another episode of Ad Nauseam.
Thank you, Amy and Daniel. If you have any questions for Amy or Daniel, their contact information is in the show notes. For more information on the latest developments in ad law, visit our Adventures in Law blog at www.adventures-in-law.com and check out all Ad Nauseam episodes by subscribing to Baker Hosts wherever you get your podcasts. As always, thanks for listening to Baker Hosts. Comments heard on Baker Hosts are for informational purposes and should not be construed as legal advice regarding any specific facts or circumstances. Listeners should not act upon the information provided on Baker Hosts without first consulting with a lawyer directly. The opinions expressed on Baker Hosts are those of participants appearing on the program and do not necessarily reflect those of the firm. For more information about our practices and experience, please visit bakerlaw.com.